Welcome to the Deep Dive, where we really try to unpack complex ideas. Today, we're diving into something pretty central, actually, how truth gets uncovered in the Indian legal system. We're focusing on witnesses and evidence, specifically under the new Bharatiya Sakshya Adhiniyam 2023, the BSA. Now, it's worth saying, while it's new, it largely builds on the old Indian Evidence Act from way back in 1872. So think of it less as a total rewrite, more like a significant refinement, maybe, our mission today, to give you a kind of shortcut to understanding of the key bits, like who gets to testify, what information is off limits, privilege, how do they question witnesses, and the judge's role in all this, which is huge. Okay, ready to get into it.
Absolutely. And, understanding these rules isn't just for lawyers. It's really fascinating because these principles, they underpin the whole search for facts, for justice. Grasping them gives you some surprising insights into how evidence actually works, how truth is sort of constructed in a courtroom, why things you see in legal dramas maybe play out that way. It's really about the bedrock of what we accept as fact, legally speaking.
That's a great point. So let's start with what seems simple. Who can actually give evidence in court? The BSA seems, well, surprisingly inclusive, right? Almost everyone is presumed competent unless proven otherwise.
That's exactly it. The core test under the BSA isn't about who you are, your status or background. It's about what you can do right there in the moment.
Yeah.
Can you understand the questions being asked? And can you give rational answers? If yes, generally, you're competent.
Okay, but there must be exceptions, things that disqualify someone.
Oh, definitely. Section 124 lays them out.
Right, like children tender years, as the law puts it. It's not just about age, though, is it?
No, it's about their understanding. Can they grasp the questions and answer sensibly? The court actually does a preliminary check, And interestingly, a child might not even take an oath initially, but their evidence can still be admitted.
Huh. Same for extreme old age, I guess, if cognitive ability is impaired.
Exactly. And disease too, body or mind. But again, the key is impairment. Does the illness stop them from understanding or answering rationally? Not just having the illness itself. And there's a catch-all phrase. Any other cause of the same kind broadens it slightly.
But what doesn't disqualify? I read something interesting there.
Right. So conditions like idiocy or lunacy, using the older legal terms, or even drunkenness, don't automatically disqualify. Someone experiencing mental health issues, a lunatic, can testify during lucid intervals when they can understand and respond rationally. And what's really quite modern, or adaptive anyway, is Section 125 for deaf and mute witnesses. They can testify by writing or even using signs in open court. And crucially, that's still considered oral evidence. The law makes space for them.
That's quite progressive. And quickly, the oath. Section 126. It's required, but what if it's missed?
Yeah, they should take an oath or affirm. But if you don't, the evidence isn't thrown out. It just affects its weight, how much importance the court gives it.
Okay, so that's who can speak. Now, what about things that can't or shouldn't be disclosed? Legal privileges. This is where it gets really interesting.
Yeah, secrets and safeguards. First up is state privilege, Section 129. This basically allows the government to hold back unpublished official records, things related to affairs of state, if revealing them would harm public interest or, national security.
And who gets to decide that?
Well, the permission comes from the officer at the head of the department concerned. They get the first call.
So they just say, nope, secret, and that's it.
Not quite. And this is crucial. While the department head has discretion, the courts, they absolutely retain the power to scrutinize that claim. They're the ultimate arbiter. Courts can, and sometimes do, inspect the documents themselves, privately, in camera, to make sure the privilege claim is legit and not just, hiding something inconvenient. It really raises that big question. How do you balance transparency, which we need, with genuine security needs? It's a constant tightrope.
Definitely a tightrope. Okay, what about other secrets, like between a lawyer and client?
That's professional privilege. Sections 132 and 133 cover related areas, but 132 is the big one. Confidential communications with legal advisors, protects talks between clients and their lawyers, barristers, attorneys, pleaders. The idea is simple. Clients need to be able to speak freely, tell their lawyer everything, without fear it'll end up in court.
And how long does that last?
Forever, basically, even after the lawyer's job is done. Unless the client decides to waive it, gives permission.
But there must be limits, right? You can't just plot a crime with your lawyer.
Exactly. Section 132, subsection 2 makes that clear. The privilege does not cover communications made in furtherance of any illegal purpose. Or if the lawyer observes facts showing a crime or fraud has happened since they were hired. So yeah, no, using your lawyer as a partner in crime under this shield.
Makes total sense. And there was another one, Section 133.
Yeah, briefly, that's about protecting a witness who isn't actually a party in the case. They can't be forced to produce their private property documents, their title deeds, if those documents might incriminate them. Another layer of protection.
Okay, shifting gears again. Let's talk about something, well, often controversial, approver testimony.
Yes, the approver. Section 138. This is an accomplice, someone involved in the crime who gets a pardon or maybe a lighter sentence for testifying against the others involved.
A key tool, I imagine, especially in complex cases.
Definitely. And legally speaking, Section 138 is crystal clear. An accomplice is a competent witness. And here's the real kicker. A conviction is not illegal just because it rests only on the uncorroborated testimony of an accomplice.
Wow. Okay, hold on. So legally, just the approver's word can be enough to convict someone.
Legally, yes, but, and it's a massive but.
Knew there'd be one.
Right. Section 118A, illustration B, brings in the rule of prudence. While the accomplice is competent, the court may presume they are unworthy of credit unless he's corroborated in material particulars. So legally okay, but practically, courts are told, be extremely careful. Trust, but verify. Extensively.
But why so much caution? Seems obvious, but spell it out.
Well, think about it. They're criminals themselves. They have a massive incentive to lie, to save their own skin, get that pardon or lighter sentence. They're often, not exactly paragons of truthfulness to begin with, so the court has to ask, is this person telling the truth now, or just saying what gets them the best deal?
Makes sense. And the corroboration needed, does every little detail have to match up?
No, not every single detail. It needs to be material. It has to connect the accused person directly to the crime in some significant way. It needs to make the core of the approver's story against that specific accused believable.
Okay, got it. Let's move into the courtroom itself, the questioning. The courtroom dance, as you called it. How does that work? Order of battle.
Yeah, Section 140 lays out the order. It's quite structured. First, examination in chief. That's when the party who called the witness asks questions.
Okay, your witness, your questions first.
Then, cross-examination. The other side gets to ask questions.
Right, the grilling part.
Often, yeah. And finally, re-examination. The party who called the witness gets another go.
What's the point of each stage?
Examination in chief is to get your favorable facts out. Cross-examination is for the other side to test the witness's truthfulness, maybe find new facts helpful to them, or even poke holes in their credibility to impeach their credit. Re-examination is to clear up any confusion or ambiguity that came up in cross or explain things further. And if something totally new comes up in re-examination, the other side gets another chance to cross-examine just on that new point.
It's a real back and forth. Now, within that, leading questions, what are those again?
Simple definition, really.
Yeah.
Section 146. It's a question that suggests the answer the asker wants or expects, like, you saw the red car speed away, didn't you? Instead of, what did you see?
Putting words in their mouth.
Essentially, yes.
So when are they allowed? Because you can't just feed your witness answers, surely.
Exactly right. So rule is generally forbidden in examination in chief and re-examination.
Yeah.
Section 146.
Yeah.
Unless the court allows it for like introductory stuff. Yeah, is your name John Smith? Or things that aren't really in dispute.
Okay, but allowed in cross-examination.
Yes. Section 146 too. Generally permitted in cross. Because cross-examination is adversarial. You're supposed to be testing them, probing, challenging. Leading questions are a tool for that.
Got it. Chief or exam, mostly no leading. Cross-exam, mostly yes. Makes sense. Now, how far can that cross-examination go? The scope of scrutiny. Section 149 sounds intense.
It can be. The law allows questions in cross-examination to do three main things. 1, test his veracity. Are they telling the truth? 2, discover who he is and what is his position in life. Background, credibility check. And 3, this is the big one, shake his credit by injuring his character. And crucially, this is allowed even if the answer might incriminate them or expose them to some penalty.
Whoa. Injure their character, even if it incriminates them? That sounds rough on the witness. Are there protections? Can you just ask anything?
No, thankfully. Sections 150 and 151 provide safeguards. The court can forbid questions it thinks are indecent or scandalous, or questions clearly intended just to insult or annoy the witness, or even proper questions asked in a needlessly offensive way. The judge has to weigh whether the attack on character is actually relevant to the witness's credibility on the specific facts they're testifying about, or if it's just, mudslinging. It's that balance again. Rigorous testing versus protecting the witness's dignity.
A constant balancing act. Okay, this leads to something really counterintuitive for many people. Compulsion to answer. Section 148.
Ah, yes. The aha moment, as you put it. A witness cannot refuse to answer a relevant question just because the answer might criminate them or expose them to a penalty or forfeiture.
Seriously, they have to answer, even if it makes them look guilty of something.
Yes, the duty to aid the court in finding the truth overrides their personal discomfort or risk in that moment. But there's protection.
Okay, what's the protection?
It's vital. If the court compels them to answer such a question, that specific answer cannot be used to prosecute them for any crime later on. The only exception is if they are prosecuted for perjury for lying in that very answer.
Okay, so you have to answer, but the answer itself is shielded from future prosecution unless you lie. That's a fascinating compromise. But this applies to witnesses, right? Not the person actually accused of the crime.
Absolutely critical distinction. No, this does not apply to the accused in a criminal trial. The accused has a fundamental constitutional right against self-incrimination under Article 20. They cannot be compelled to be a witness against themselves, period.
Yeah.
This compulsion is for witnesses, not the accused.
Right, that's a huge difference. Okay, another awkward situation. The hostile witness, Section 157. What happens when your own witness turns on you?
Yeah, it happens. You call someone expecting them to support your case, and they suddenly become antagonistic or give testimony that hurts you. They go hostile. The party who called them can then apply to the court for permission to basically treat them as if they were the opponent's witness.
Meaning you can cross-examine them, your own witness.
Exactly. The court can grant permission to cross-examine your own witness.
What does that achieve? And does it mean their whole testimony is just ignored?
Good question. No, it doesn't automatically mean their evidence is worthless or inadmissible. That's a common myth. It means you can now ask them leading questions, confront them with previous statements they might have made that contradict what they're saying now, try to shake their story or show they're unreliable. But the court still weighs their evidence. It might give less weight to the hostile parts, but it can still accept parts that seem truthful or are backed up by other evidence. The aim might be to refresh their memory, pressure them into telling the truth, or at least demonstrate to the court that this particular witness can't be trusted.
Okay, so not thrown out, just handled with extreme caution, and you get to challenge them directly. Right, let's wrap up the main discussion with how you actively try to discredit a witness, impeaching their credibility. Section 158. How's it done?
There are several ways laid out. First, you can bring in other witnesses to testify about the first witness's general reputation. Basically, people who know them saying, yeah, based on what we know, we wouldn't believe this person under oath. General reputation for untruthfulness.
Ouch. What else?
Second, proof of bribery or any corrupt inducement, showing they were offered or accepted something to testify in a certain way.
Yeah.
That obviously hits their credibility hard.
Makes sense.
Third, and this is very common, proving they made previous statements inconsistent with their current testimony, showing they've said different things at different times. Section 159 details the procedure for how you confront them with that.
Contradictions. Always powerful.
Absolutely. And fourth, this one has a history. Section 158(4). Specifically in cases of rape or attempted rape, the law technically still allows impeaching the complainant by showing evidence of her general immoral character.
Wait, really? That sounds incredibly problematic.
It is, and it's crucial to understand the context here. While that text remains in the BSA, reflecting the old law, modern courts are highly critical of relying on this. Judicial interpretation has moved significantly. It's seen as outdated, often unfairly targeting the victim, and largely irrelevant to whether the specific act of rape occurred. Courts focus much more on the specifics of the incident, not on general character assassination based on patriarchal notions. It's a prime example of how judicial interpretation can evolve the application of law, even when the written words haven't caught up yet. It raises questions about how law reflects or lags behind societal values.
That's a really important point about legal evolution. And of course, cross-examination itself under Section 149, injuring character, that's also a way to impeach, right?
Definitely. Cross-examination is probably the primary tool used in practice to shake a witness's credibility directly.
So, okay, pulling all these threads together, what does this all mean for you listening? We've gone through this deep dive into the BSA, looking at who speaks, what's kept secret, how testimonies are tested. It's quite an intricate system, isn't it?
It really is. And it just underscores that constant, delicate balance the law tries to strike. You need to get the facts out to ensure justice is done, but you also have to protect people's rights, privacy, dignity, and maintain the integrity of the whole process. It's a non-stop negotiation.
Yeah, and it makes you think, doesn't it? How these technical rules, they're actually shaping our very idea of truth within the courtroom walls. How does this structure the way we present evidence, challenge it, decide who speaks? How does that fundamentally affect what society, through the court, ultimately accepts as fact? What other questions does this bring up for you about justice, about fairness, about how we decide what's true? Maybe next time you watch a courtroom scene or read about a case, you'll see these principles playing out with a bit more clarity. Something to think about.